Welcome, everybody, to our webinar today on social media. Before we start the program, I would like to share some housekeeping information. First, this is not a CLE accredited program. Second, you may submit questions at any time during the program using the Q&A function at the bottom of your screen. Finally, this program is being recorded. Welcome to Social Media as Evidence, sponsored by the ABA Criminal Justice Section. I'm Angela Albertus, a director at the National District Attorneys Association, and I will be moderating today's program. Our panelists today are Robert Kline and Jennifer Leeser. Robert is a deputy supervisor in the juvenile division with the Cook County State's Attorney's Office. He has been with the office since 2007. In addition to his work with Cook County, he is also a faculty member for the Illinois Juvenile Prosecutors Institute and the National District Attorneys Association. Jennifer is a partner at Kaplan, Marino. She handles white-collar and complex criminal matters throughout the country. She also leads the firm's internal investigation and corporate compliance practice group. Today, we will cover how to get data from social media companies and smart devices, common practices, things to avoid, and evidentiary rules that govern this type of evidence. The format today will be a panel discussion. Let's now begin. Jennifer, I'd like to start with you and ask, how are you utilizing social media in your cases?
Social media comes up pretty frequently in usually more of my complex criminal matters as opposed to my white collar matters. And a lot of times the most obvious use is alibi and with regard to our client, the defendant, and then also with regard to the alleged victim. It comes up a lot in terms of what an alleged victim may have said prior to or leading up to or after the alleged offense. It can also come up in terms of, more straight, like criminal matters in terms of self-defense issues. And then we also, for some of my more white collar or complex matters, we also use the metadata from the social media posts. So the date, time, sender, receiver, again, for alibi purposes to try to determine or establish that perhaps my client was somewhere else when a particular message was sent, or that the alleged victim, or even, in the white collar matters, that it couldn't possibly have been, as the government establishes, in terms of when a message or communication was sent.
You mentioned self-defense. Could you elaborate on that?
Yeah, so in more traditional cases, like just, you see it come up, if you look at the case law, it comes up a lot in terms of, murder or attempted murder cases in which a defendant claims self-defense for the murder or the attempted murder. And so if there is evidence of the victim engaging in, posting on social media about violent acts, or, that he's going to, take steps to harm the defendant or the defendant's family, or anything like that, that indicates that what actually happened with regard to the offense conduct might have been fueled more by the victim as the first aggressor, as opposed to our client or the defendant. And then you can also see it, let's say it's not a murder case, or it's attempted murder case, or it's an assault or something like that, examining the social media of the victim after the fact can also be helpful in terms of establishing that perhaps, again, the victim was the first aggressor, the alleged victim was the first aggressor. It's amazing how much stuff actually gets posted onto social media and how frequently it can actually come up. The common sense of, like, maybe that's not a good idea is not always heeded. And so it comes up quite frequently, and it's step number one, especially when you have these traditional general crimes, to make sure that you're examining the social media to see how it may help you in your case.
Robert, could you discuss how you're usually utilizing social media in your cases?
Yeah, typically, I'd say on our cases, we kind of learn because the crime itself tells us that social media was involved in this. Think of disorderly conduct cases where somebody's making a school threat about either blowing up a school or shooting up a school that's posted on social media. We know right off the bat we need to be looking at this. There's a number of different robbery situations or vehicular hijackings where there was some kind of ruse set up on Facebook Marketplace or Meetup or another app for somebody to try to sell or pick up something. And so we're learning from our victims. This is what's used to set up the commission of this offense. And so we need to start going after that, and law enforcement start searching for that types of information. It could also be some of the things that we learn after the fact as law enforcement continues their investigation, whether it is through a statement of one of the offenders that talks about how they used social media or they posted on it and they're able to find it that way, whether it's a phone being recovered from an alleged offender and a search warrant being executed on that phone and information being found on that phone. Or sometimes it's when law enforcement is looking at a suspect and they can see social media posts that the individual is doing maybe before or shortly after the time of the crime. And they're wearing maybe a unique outfit that day and they posted about that outfit. And lo and behold, the individual who committed the offense is wearing very, very strikingly similar outfits. And we're able to capture that, get that as circumstantial evidence of that individual being involved in the crime. So it's kind of all sorts of ways that we're getting to see it, and it's more and more frequent as I think as Jennifer was talking about. It's utilized so frequently now. Almost everybody uses social media, and so we're able to utilize that a lot of the time on our cases, or at least we're searching for it every single time almost.
And Jennifer, could you explain how you obtain social media evidence and what are some of the barriers to obtaining social media evidence?
Yeah, so this is a really interesting legal dilemma for the defense in terms of obtaining social media when your client was not a party to the communication. So let's say that you become aware that an alleged victim posts something on social media that is exculpatory to your case. Let's say it's like a smoking gun, I mean, it's like, I attacked this, this person first, whatever it may be. If the prosecution, so there's something called the Stored Communications Act, which governs the disclosure. It's a federal statute, and it governs the disclosure of these private online communications. So any company that stores, retains private communications or any sort of data is not allowed to just disclose that to the general public for privacy purposes. But there are these exceptions for law enforcement. So they will disclose with a valid search warrant that establishes probable cause. And there were exceptions built into the statute when it was first enacted back in 1986. The problem is there are no exceptions for a criminal defendant in serving a subpoena for those same communications. So if the government does not execute a search warrant to get those communications and then disclose them as part of Brady, and a client defendant is not otherwise able to obtain those through other channels, let's say like subpoenaing the person who made the post, then they have to go to the service provider like Facebook, Meta, Snapchat, whatever it may be, to try to subpoena or request those materials. And the service providers generally cite the Stored Communications Act, stating that they cannot and will not disclose private communications. They will disclose public posts. So if a user makes a post public, or if their account is public, then they will disclose those because the user has already taken the affirmative steps to make it public, and it's no longer considered a private communication. But if you have select friends on Facebook, for instance, and you make a post, the social media companies will push back because of the Stored Communications Act, and they'll push back hard because they have they're concerned about their users, and they have the resources to be able to do so, right? So what ends up happening is a defendant can serve a subpoena, um, if the court orders production. Typically, still, the the social media giants will push back, citing the Stored Communications Act, and you can see where constitutional issues come up, Fifth and Sixth Amendment rights. I mean, that could be your smoking gun. I mean, your right to a fair trial, and you can't get that information. So what's been really interesting, and this is not across the board, but at least in California where I practice, there's a recent, just like a brand new case. And it should be in the materials that will be circulated to you, but it's Snap, with Snapchat. The California Court of Appeals actually determined that these service providers are not governed by the Stored Communications Act because they mine users' data. So you sign a release when you sign up for Snapchat, Facebook, whatever it may be, allowing these social media companies to use your data to sell it to third parties, and that's where you receive targeted ads. And since the data is then being used and disclosed for monetary or another purpose, it's no longer private, and therefore the court ruled it's not governed by the Stored Communications Act and actually required the disclosure. So that's a really significant case, because this has come up a lot for criminal defendants in terms of their ability to access these materials. So that's a pivotal case. It's going up to the California Supreme Court now, and I think we're going to continue to see these issues. It's interesting because the Stored Communications Act, and I'll cut off soon here, but it's just interesting because the Stored Communications Act has not been updated since 1986 when it was first enacted. And you think about everything that has happened since then. I mean, the World Wide Web, I mean, internet browsers, everything has happened since then. And we're still operating under this outdated old statute, and the courts are like begging Congress to update the statute, and we're just like grappling with something that doesn't really work anymore. So anyways, this Snap case is a big step forward for criminal defense attorneys.
Yeah, that was that act refers to electronic mail. That's how dated the terminology is during that. Yeah.
Robert, do you want to discuss some of the ways that you as a prosecutor obtain social media evidence and some of the barriers you encounter?
Certainly. So, yeah, the only thing that we can get with just a subpoena would be, as Jennifer's talking about, subscriber information or billing records. So if we really want to get into the content of it, we utilize search warrants. So law enforcement will draft a search warrant, and depending on your jurisdiction, if the prosecutor's offices review those prior to them being sent out by law enforcement. Subpoenas can be issued from the grand jury, but really it's search warrants that we are going to utilize if we want to get that information pre-charging. Once somebody is charged then with an offense and we're in court, we'd seek a court order for release of those, because under the Stored Communications Act, a court order along with the subpoena can typically get the information, the content that we're seeking. But aside from the search warrant or an order from a judge, There's a number of different ways that we'll do it, even the old-fashioned way. I've even had this a few years ago when a victim had their phone up. I even saw a detective take their phone as they were showing us the communications. They walked over to the copy machine, they put it right there on the copy machine, and they took a old-fashioned screenshot. We'll call that a screenshot or screen grab of the of that case, and that's just to try to, or of that communication, to try to preserve it, just in case something happens where that search warrant's not effective or that court order is not effective in getting that. So it's documented somewhere, it's obtained somehow, some kind of screen capture. There's a number of free tools that you can use online. Even just a snipping tool, if you have a Windows computer that's built into every single Windows computer, snipping tool, or the print screen function can capture whatever's on your screen at the time. So you can do a screen capture of what you're seeing right there, in addition to using other processes to try to obtain the business records if you're trying to get all of that. We also will utilize phone extractions. If somebody's phone is recovered, there'll be a search warrant on the phone, and then dump that phone to review the contents of that phone, which includes that social media content that's stored on that phone, so we can obtain it that way. So there's a number of different methods that we can utilize to obtain this information, not just the search warrant function or the order of the court that we'll utilize.
And what about barriers?
Yeah, I think I agree with Jennifer that social media companies do have a number of different barriers because they want to help their customers. They want to be seen by their customers as protecting your privacy. Even though they might be selling you out on the other end of it, they're telling you that they're protecting you with other things. So they do want to, if your I's are not dotted, your T's are not crossed on those search warrants and those court orders, they'll find any way they can to deny them. So what they'll typically do in order to make sure your orders are in good form, I would certainly communicate with other law enforcement agencies if this is something that's new to you. There's also a good law enforcement resource online. It's Leads Online. It's LEADS online altogether.com. And they have a law enforcement technology investigation resource guide, which has contacts for all the major social media companies for law enforcement. So if you need to email or get in touch with their legal counsel for these social media companies, you can go there, and it's updated and stored there, so you can look at that, aside from going to the company's website, of course. They also have a number of templates that you can utilize, tried and true search warrants or court orders, and the language that's utilized that is also updated with the times and case law, so that you can use that to make sure your search warrant or your court order's in good form and will hopefully pass muster with legal counsel of these agencies. And then lastly, I'd say a barrier is time, because a lot of these companies delete things after a period of time. It could be 24 hours, it could be 30 days. So a preservation letter is something that I always recommend if you want to try to keep something. And a preservation letter I believe it's under the Stored Communications Act. I might be wrong, Jennifer, if you know. I believe that's where it comes from, is they have a duty once we submit a letter to hold onto that information for a period of time. I think it's 90 days. And you can continue to re-up that by sending a new letter to that company. So sending just a letter, you're not even sending a search warrant, you're not sending a court order to them, you're sending a letter that's saying, I'm requesting you to preserve this information from this time period under this account, and they have a duty to hold on to that, and they can't delete it once they have that. That gives you time to get your search warrant or your court order ready to go. Examples of preservation letters are also available on that website. If you also, my information is going to be on this at the end. If you were to email me and ask me, I can give you an example of a preservation letter too after this is over.
Yeah, I
Thank
think
you for
preservation.
providing.
Yeah, sorry, Angela. Preservation letters are like essential no matter what. I mean, we send those out right away. regardless of where we're going, just to make sure that that data is preserved, especially when you think about something like Snapchat, where the communication is deleted pretty quickly. I mean, it's just absolutely essential. And I think it is, for the preservation letter is under the SCA. I think it's 2703 subsection F.
I'm going to just go to the chat for a minute where the Q&A and ask some questions. AI systems need data to function, so can all the publicly available data on social media be utilized? Would it be a violation of right to privacy?
So generally speaking, publicly available data is publicly available. So there are no privacy rights because the user has taken the affirmative steps to make it public. So it's not, it's it's not protected under the same provisions of the SCA or any sort of privacy laws.
And then another question, can defense attorneys use the subpoena and court order to compel tech companies to provide data?
Yeah, so that's kind of what I was talking about. It's really interesting. You can, depending on your jurisdiction, you can issue a subpoena. You can do that. It doesn't mean that the tech company is going to comply, even with a court order. I mean, even, if court says, yes, yeah, absolutely, this, you've met the threshold requirements in your jurisdiction, whatever they may be in terms of the factors for, get around any sort of motion to quash, and the court does issue an order to compel, production of the records. The social media companies, in a lot of instances, will still push back. They'll take it up. I mean, they have, like I said, they have good reason to, with the idea that if users believe that their communications are in fact not private and can just be disclosed, I mean, that could erode the confidence in the social media systems. And so they have a real incentive to try to push back. And in my experience and in looking at the case law, I mean, that does happen pretty regularly.
And Jennifer, you mentioned some of the constitutional issues involved in obtaining social media evidence, particularly from the defense perspective. Do you have any other additional advice about, how defense attorneys can navigate social media giants in terms of these constitutional issues?
I mean, you can always make a constitutional challenge. And then I think, as Robert was discussing, you have to think outside the box. Let's say you don't have the resources to continue to fight Meta, and they're, taking a writ and they're taking it up, and you're running out of time. You have to think outside the box, like what other ways can you access the data? So if for instance an alleged victim is not deceased, you can try subpoenaing those communications from the alleged victim or from the witness directly to try to circumvent some of the SCA's provisions or the social media giants pushback trying to cite to those provisions. Obviously, if your client is connected to a witness or a victim, then that's really easy because they can access the communications themselves. And then in my experience, the government is always trying to do the right thing. So it's always worth having a conversation with the prosecution to see what they're willing to do. Perhaps they're willing to assist you in obtaining those communications too. At the end of the day, we're all just trying to get it right.
Robert, when you receive voluminous records in your cases, what are some tips and tricks that you can provide to review the documents that you receive?
Yeah, it can be pretty onerous. I've had, Facebook records that come back and it's a PDF in the thousands of pages. I mean, easily over 10,000 pages of posts. It's not like they make it easy for you. They basically just give you the haystack and say, good luck finding the needle. So a lot of the times the crucial parts, if you've got something like a PDF, is to make sure you've got your Adobe account paid for so you can use the search function in there. But really looking at and trying to narrow down key dates and times in there. Making sure that you understand that some of these things are time stamped differently. It might be on a universal time zone, so it might be hours ahead or behind where you are. So you want to make sure that when they send it to you, they'll tell you what time zone. It's usually universal. Then you can do the math in your head to try to pinpoint your time frame. If it is something a little bit easier, I think Snap has started sending some things in Excel, which Excel is a lot easier to search through and use that Control F function. There's also some pretty good readers out there. Cellbrite Reader is a free reader that you can utilize. And this is not only, it's commonly used for cell phone extractions, but social media companies are sharing data in the UFDR files so that you can use a reader in order to like Cellbrite in order to review these things. And when you open it up, it actually has a timeline function on there because you're going to get gigabytes upon gigabytes of data that you're going to be looking through. But what narrows it down is sometimes there's a bunch of different ways it's narrowed by text files, video files, social text messages. They'll also have social media that you can do, Google searches. But the thing that I find is the easiest is go to the timeline function on there, and it puts everything that's happening on that phone into a big timeline. And you can use the narrow function on there and narrow it down to the exact time range where you're looking for. And what that reader does, is it actually reduces everything into just a narrative. What happened minute by minute on this device or on this account as they were utilizing it? Was it posts? If it's a phone, were they searching during this? Were they messaging? And that really is clutch in narrowing down and figuring out what it is that you want to find and locate. So that's kind of how I utilize it. I really rely on those reading devices or Control F. That's my friend.
Jennifer, do you want to add anything to that in terms of tips and tricks for voluminous records?
Yeah, I mean, look, I'm a white collar practitioner, so I'm like very used to voluminous records. I mean, there's always hosting platforms as well. If you have the resources for it, Relativity, Everlon, there's just like countless. I just started using this one called IntelliConnect. I mean, there's a whole bunch of third-party platforms out there that you can also host the data. And, it makes it searchable. You can run queries and it can narrow the data set as well. But specifically when it comes to social media, sometimes it's hard because you don't know exactly what it is that you're looking for. And then, there's nothing you can do other than a manual review. I mean, but like Robert was saying, usually the timeline function, the general time frame in which you're looking, and so it can narrow the data set just simply by the timeline.
One thing
Okay,
I do want to add, Angela, to that is if you did have a court order or a subpoena for records, you really got to double check when you get those back. If you want to utilize them as a business record, you really got to make sure that there is a certification and an affidavit attached to that, because many states will require not just a certification, but an affidavit on there. So know what your state's rules of evidence are for business records and make sure that they're complying with it. In my experience, I have found that when I've just gotten that certification, and in Illinois, we require both the certification and an affidavit. I found that when it's just the certification that comes, if I communicate with their legal and ask for that, I've gotten that affidavit then sent to me relatively quickly after that. But if you don't get that and you're going to trial, you're out of luck if you're trying to admit it as a business record when you don't have it the day of trial. So just be cautious of that.
Thank you. Okay, there's a question about the SCA, the Stored Communications Act. It does have an exception for an individual trying to obtain their own content. Have you had success obtaining the content of a client's account from a company covered by the SCA when you have the client's consent? I believe many of them typically respond that someone can simply download their account content, but there are many situations where the client can't download their own data, incarcerated, forget the password, and things like that.
Yeah, I mean, if there's consent, that it shouldn't be an issue in terms of being able to access your own data, because it's your data and there's not the privacy concerns. The SCA is really about disclosing the communications to third parties or the public. So, that really shouldn't be an issue.
Another question, Jennifer, we may be looking for sample subpoenas for Meta, etc. Do you have any ideas for resources to find those? I was previously a state's attorney, so as Mr. Kline noted, all of my resources are pretty much search warrant or grand jury subpoena based. Thank you.
Yeah, so I mean, the subpoena is really going to depend on your jurisdiction. I know in California and even in some federal jurisdictions, all you have to do is issue the subpoena. And then if there's a motion to quash, that's when you're combating whatever the factors are in your jurisdiction. So, Nixon factors federally, something called the Alhambra factors in Alhambra, sorry, that might not have come out that well, in California. So, that's when you really get into the need for a little bit more nitty gritty. And then you just have to run through the factors in your particular jurisdiction as to why you need these materials, establishing good cause for why you need these materials.
Okay, there's another question. It's a follow-up question, I believe, to a previous question, citing a case, Perry versus United Kingdom. It was stated that data of public nature falls within the private life of an individual when systematically collected, stored. So if social media, particularly when AI is used in criminal investigation, using data on social media, which would be put through some AI model, would it not violate the right to privacy of any person?
Now you're citing a European case, so it's a little bit outside of our purview. I can say I've never utilized AI, and in Chicago at least, I've not had law enforcement utilizing AI for any of this evidence gathering. But I do note in in the United States, some of the case law that's come down. I know Commonwealth versus Carrasquillo, which is a Massachusetts Supreme Court case, discussed rights of privacy, and it really, when it comes to social media, really depends on what that person is putting out there and posting, if they are, and what their privacy settings are on their account, and knowledge of that. Some of the factors are, do they have knowledge of what their privacy settings are? What were those set as? Were the individual or individuals who collected that data, were they a friend? This is a case where it was a law enforcement agent who was posing on social media and friended the individual and obtained information that way. So they kind of looked at that function as to what that individual was using social media for, and their knowledge and use of the privacy settings on there.
I'm going to move to another question. Is it possible to get posts already deleted by the users by using subpoenas to the social media companies?
Depends on the length of time that's elapsed, really. I mean, it goes back to the same thing that we're talking about with subpoena. I mean, obviously a search warrant would be more effective, or, a court order, for the same reasons that we've already discussed with regard to the SCA. But it's really going to depend on the storage policy of the social media company. And then that goes to Robert's point of, initially get that preservation letter out so that hopefully it can be preserved.
Robert, do you want to add anything to that?
No, that's absolutely, I agree with everything Jennifer said on that.
What are some of the issues and cases involving social media that you have to consider as part of jury selection? Jennifer, do you want to take a stab at that question?
Yeah, this comes up a fair amount for me in my cases, where like particularly I handle a fair amount of public corruption cases. And so by the time that a case is going to go to trial, there's been a lot of publicity on the case already, and social media by, perhaps my client, by the witnesses, by the news, right? It's all over social media and the internet in terms of the allegations, and it can infect and bias a jury pool. And so in terms of jury selection, that's really important, um, to screen your jury with jury questionnaires to ensure that the jury pool that you're getting is at least as insulated as possible from any sort of coverage already circulating surrounding the case. Um, and I have found through the use of like actual written jury questionnaires and then, further selection that, typically the system seems to do its job and you can get a clean jury pool. And then, it's also important during trial to make sure that, you know, that the jury is admonished that, they can, again, they cannot, access the news or social media during the pendency of the case, because of course the coverage is going to get even more extreme while the case is actually pending.
Robert, what are some of the issues that you have to deal with in terms of jury selection?
Yeah, I would think, a common thing that prosecutors always talk about when we get together and gripe is, with juries, the CSI effect, and that's a dated term even now, but it's really with the, more publication of forensic evidence and what that entails, the expectation of a juror that there's going to be some forensic evidence presented here, or if there's not, why wasn't there? What am I missing? And I feel like as we continue to see more and more growth with social media and people utilizing it and it being part of our cases, it's something that we need to take into account when we're prepping for trial. If we have any social media evidence, how we're going to be presenting that, and how savvy of a juror we need, how tech savvy of a juror do we need to be able to understand some of the posts, some of the lingo that's being utilized, how this stuff is transmitted, and how it might track a person. I mean, it's easy if you're like, well, I'm just utilizing it because there were a couple pictures that were posted. That might be a little bit easier. You're not too worried about it. But if it's more about you're utilizing metadata, as Jennifer was talking about, or if there's any IP information that you are utilizing, IP addresses, do I need to make sure my jury understands that? Do I need to make sure in my voir dire, I'm asking questions about their tech habits, their computer knowledge, and social media experience? I think that absolutely is something that's going to continue to grow, is something we'll have to prepare for and be ready for at voir dire.
And Robert, you mentioned admissibility earlier.
Yes.
Could you talk about some of the legal issues that you encounter in terms of the admissibility of social media evidence?
Yeah, it's social media. It can be something that we're looking at, and if you don't utilize it frequently, it might be very foreign to you and kind of scary, because I don't understand it. How am I going to be presenting it? It is no different, and I think that lawyers need to look at it as it's no different than any other piece of evidence, similar to a letter, a phone call, a picture, a video, surveillance video, that kind of thing. It's the same rules that govern that. The federal rules of evidence 901, which is kind of mirrored by a number of jurisdictions, not just the federal, is saying to satisfy the requirement of authenticating or identifying an item, the proponent must produce evidence sufficient to support a finding that the item is what the proponent claims it is. So it is what we're saying it is. So it is a post by someone. It is a photograph posted on social media. So how do we meet that threshold? And it's not a high threshold. It is not one where absolute proof is required. It is one where it's typically like a reasonable probability standard, or a prima facie showing that it is what we're saying it is. And we can use direct or circumstantial evidence to prove that. Some of the ways that we utilize that, some of the ways we do that is the business record rule. So Federal Rule 902 along with 803, having that certification and delegation of a business record if you're utilizing social media records. And you've also got to make sure you've got to tie that. You can authenticate it that way. You've also got to tie it to the individual that you're trying to tie it to. You can't just say, here's social media records. Obviously, to be relevant at trial, we need to also make sure it's tied to, say, the defendant. So what are you utilizing to tie it to that individual? Was the device recovered from their pocket? Was it an individual that was identified in the videos or the pictures on there? Are they using phrases or terms that only an individual would know, only that defendant would know? For example, a Facebook account where somebody is posting on Facebook or direct messaging somebody on Facebook, and they're saying an address where an item is, that only the offender would know where that address is. The police went to that address, lo and behold, that item was there. Or if you've got a victim or a witness who communicates with that individual under that screen name, so they can testify, yeah, I know it was Bobby because I text with him usually on that account. We've been texting for weeks. Or even if it's just a one time, I texted him, he said to meet me at this location. I got to that location, there he was. That's another way of kind of tying it to the individual. If you don't have the business record, though, you can have that testimony of a witness with knowledge, and that is 901B1, where that individual, like receiving a text message from another individual or like a direct message on Facebook, you don't need necessarily the Facebook records to admit that. What you can have is that person with knowledge. For example, if Jennifer and I had communicated prior to today, if we'd had communications on, let's say, Instagram, and if there were messages that we were sending back and forth and we needed, somebody needed to admit one of those at a trial, that individual, the recipient, could testify, yeah, I routinely messaged with the other individual. I routinely messaged with Jennifer using that screen name. This was my screen name. There were language and content in there that only Jennifer or only I would know. And that's how you're tying it to the other individual and authenticating it. So those are just two ways that you would authenticate it. But really think about it. A text message between another individual, how is that different from a letter between another individual? How is that different from phone communications? You need somebody to be able to testify, well, I knew it was because of the handwriting they used, their signature that I'm familiar with, or their voice. I recognize their voice on the other end. We've talked many times before. It's no different than that. And if you get your mind around it that way, it can become a lot easier to grapple with.
Jennifer, could you discuss some of the legal issues around admissibility that you have to deal with in your cases?
Yeah, I mean, I don't know that it's really any different for us than it is for Robert in that sense. I mean, it could be an extra challenge if you have a deceased victim and now you have their social media account and you're trying to have that evidence admitted. But we would still go through the same process that Robert already outlined. Going back to something that Robert says, I mean, for anybody that's not super familiar with social media, I mean, you have to remember, just as a basic premise, that anybody can create an account with a user's name, right? So that's why this authentication is so important with regard to social media. It is no different, but it is also, easy to fabricate. So I can create a Facebook profile right now that says, Robert Kline on it and post a picture of Robert, but that doesn't mean that and then make posts, right? But that doesn't mean that it's actually Robert who's doing so. But it's more challenging because it may very well look like it is. And so there really is like a little bit of extra work that goes into the authentication process with regard to social media. But yeah, at the end of the day, it's no different. I think the Second Circuit, back a while ago, compared it to like a printed handbill, right? Like at the end of the day, it's the same thing as any other form of communication that we're talking about, and the same rules apply in terms of getting that evidence in. And then of course, there are the other hurdles in terms of the same evidentiary rules that we're used to, I mean, you have to be mindful of, hearsay rules, like, how are you seeking to use that evidence, that social media post? Obviously, the same rules that govern the admissibility of any other out-of-court statement apply in the same regard with regard to the social media. So you have to make sure that your use of the content falls within an exception. Other considerations are, we're in criminal cases able to, under 404, we're able to, introduce social media evidence to show, like our client or the defendant, like a pertinent trait, right? We're also able to do so with regard to the alleged victim. But, you always have to be mindful. You're using the same rules of evidence that you're always using with regard to social media. I mean, it is no different, but you always need to be mindful that you're considering the same rules of evidence in terms of admissibility with regard to social media, so that you can make sure that it comes in the way that you need it to.
There is a question about posts made under an alias or a fake account and whether they could be tied to an individual in court. So Jennifer, I would just ask, could you just expand a little bit on what you spoke about earlier regarding fake accounts and how that's dealt with in your work?
Yeah, I mean, this is going to be somewhat hypothetical, right? Because I'm not sure that this has come up for me in court, but let's say the prosecution gets it wrong. Let's say that the prosecution thinks that a Facebook account of my client that has certain identifiers, and they tie it to my client, and they think that this is his account, and there are, certain certain things that they believe pointed to my client. You're going to have to combat that then, right? Like, you're going to have to say, like, you're going to have to point to all the evidence and the reasons why it's not your client, in the same way that you would, anything else, right? I think, like, at the end of the day, social media is, like I said, it's no different than anything else. In the same regard, I mean, like, you see this come up sometimes with some of these crimes where, like, it's sick, but people will create a fake Facebook account of a deceased victim, and try to use that Facebook account. And there's always, like, identifiers or indications of the fact that it's not really the individual, right? Like, you can look at the date that the account was created. You can look at the metadata, right, that Robert and I were previously talking about, if you are able to get the records from the social media company. You can look at IP addresses to see where posts were generated, the time in which they were posted. There's this underlying, not just surface value data that goes along with the production of records from these companies that has some of that data that can go towards the authenticity of who actually created it. And those are very useful in terms of combating an allegation or some sort of situation in which it's not the same person, right? Even though it looks like it isn't actually.
We have another audience question. How does geolocation data from social media factor into criminal or civil investigations?
Yeah, we'll utilize geolocation data to try to plot individual, like you can utilize Google Earth and other mapping softwares, and you can utilize that to try to track an individual as they're going around, just like you would with cell tower records if you were looking at that. So there certainly is geolocation information that can be plotted and plugged into software and then utilized in court by having an agent testify, maybe if it's somebody from the FBI or other law enforcement that's familiar with how to plot those points and then create those maps and present that in court, you'd utilize that. It's absolutely something I know the FBI testifies routinely in state and federal investigations, and they have a unit that will review cases and review and plot those things. And there's also, depending on your location where you are, and I'm fortunate, I'm in Chicago, so we not only have Chicago police, but the other surrounding suburbs form networks to work on when it's very big cases and investigations, and they have investigators that specialize in just that. So you'd utilize that, and then you'd present using those agents or officers in court.
Jennifer, would you like to add to that?
No, I mean, it's the same thing for us too, right? Like as I was talking about IP addresses, you can use geolocation too for the same, to try to establish the same thing, right? It works the same way, right? My client is accused of committing a crime, and he says, well, I wasn't actually even there at that time, and you can pull his social media and geolocation and demonstrate, like he actually wasn't, like, I mean, there's always still issues, right? His phone could be somewhere else. There's always like arguments to counter it, but it's certainly a helpful piece of evidence.
Another audience question, are there ethical concerns in using AI to analyze or predict behaviors based on social media data in legal cases?
Boy, I think AI and the law is an ethical quandrum that could absolutely take up many multi-hour panel discussion. I think offices are, and I don't know about your practice, Jennifer, but I know a lot of offices are working currently on creating policies regarding utilizing AI. And I think that's a pretty big issue we're going to be talking about for a long time.
Yeah, I agree. I mean, it is its own discussion. It really is. And, more to be seen. It's also just, with each, like federal government, like how they're going to choose to, support or not support AI. I mean, it's just, it's an interesting issue in and of itself.
In another year, AI will be doing this panel. It won't be Jennifer
Yes.
and Angela and me. It'll be just AI. It'll be avatars that are talking.
Yes, much smarter than us. It's for sure.
So a final question for our panelists. Could you discuss any emerging issues that you've seen in recent months or the last year that we haven't talked about yet?
I'll go first, if you don't mind, Jennifer. Is that all right?
Yes, yes.
I would say that a lot of the social media changes, there's new companies that sprout up overnight. What you used last year, you might have used WhatsApp last year. Now you're using your company switched and they're using another platform when you're messaging. So the companies change all the time. The kind of basics around it don't change. The thing that I am seeing that we're going to get more and more into is going to be compelling biometrics and compelling passcodes of people's cellular devices. I think that is something that's emerging. There's been a number of different cases in the past 2 years that have come out about compelling an individual's face to unlock a phone, or fingerprint to unlock a phone, or their passcodes. And depending on your jurisdiction, they are saying, yes, the prosecution can file a motion and compel it if they meet the foregone conclusion doctrine. And other jurisdictions are saying, absolutely not. You can't do that. And so I think that is, in the next year, we're going to see a lot of advances with that and getting into people's personal devices and what the courts rule on that. That's the biggest thing that I'm seeing in the next year.
Jennifer?
Yeah, I mean, I totally agree with Robert. I mean, that is really like the hot button issue right now with regard to these devices. Other things that are coming up, I think, as we use technology more and more in the workforce, we're seeing it come up a little bit more with regard to these video platforms. For instance, this webinar is being recorded right now. That means that Zoom also retains a copy of this this recording and could be compelled to disclose this recording. So some of these things that we don't really think about in terms of what is actually being maintained by companies, and we always just want to be mindful of. I mean, do we care? Do we not care? What do we want to do? You know, I have a case right now. It's a tax fraud case, and they communicated via Zoom, and one of the particular Zoom sessions was recorded. And nobody really thought anything of it at the time, and now it is a crucial piece of evidence being used against my client and his co-defendants in this case. And the entire like hour plus Zoom meeting is available and there and recorded. And you know, so really as a criminal defense attorney, that's always something to caution your clients about and make them mindful of, in terms of the fact that, you know, this data is retained and can be produced via search warrant. So, you know, just always be mindful.
Okay, we have 4 minutes remaining. I'm happy to take additional questions if there are any. Would ask that if you have a question, you type it in. We could probably take 1 or 2 more questions before we conclude. Down to 3 minutes now.
One thing I'll say while we're waiting for questions, you know, we touched on this, but I think like something that always seems very appealing and alluring is to you know, have your investigator create a social media account and like friend the person that you're trying to get the data from, and then be able to access the data. That's a big no-no. It doesn't usually work out so well in terms of admissibility, so don't do that. Not a good practice.
Okay, I'm not seeing any more questions, so I want to thank the ABA for having this training today, and want to thank our wonderful panelists for providing such comprehensive information on social media as evidence. And I want to thank our audience for such insightful questions that enhanced the presentation today. Thank you, everybody, and have a good day.
Thank you.
Thank you.